important provision of Article 13, ये तो कहानी था, that is our clause 3. 3 talks about कि what is the meaning of the word law. और सारा constitutional amendment इसी कहानी पे टिका है, ठीक है, कि what is the meaning of the word law under Article 13. So write it down, Article 13. In fact, if I can open Article 13 on this, that will be much better. Huh? Yes, that will be much better. Okay, articles, yeah, yes. So let us freeze it. Yes, it is frozen. Okay. So clause 1 and clause 2 we have seen already, right? So clause 1 done and clause 2 is done. Okay. Let us now talk about clause 3. Clause 3 is the most important clause perhaps. What does it say? It says, in this article, unless the context otherwise require, the word law includes, very important word, law, right? Because above the use of the word law is this, here is the law, here is the word law, right? So what do you mean by this word law? Which law we are talking about? So there is a debate, and the debate actually essentially is, okay, here there are 2 types of law that exist or that is made by the parliament. One law that is statutory, made on the different subjects, and one law parliament also amend the constitution. So that is also a law, and the law made on the statutory subjects is also a law. So which law they are talking about? That is the question, right? So here, if you look at the definition, it says that the word law includes ordinance, that is a bylaw, right, provided under the constitution, order, rule, regulation, notification. These all are basically variation of the same thing, can administrative acts. Now the modes of administrative action may be different. It may be called by different names. Okay, it may be called even guidelines. Right, Government of India comes up with a guideline. So guideline is not given, but still it will come within the meaning of the word law. It is simply the nomenclature, nothing else. But a critical thing is custom or uses. Now that is very important. Custom, not made by any legislature. Uses, not made by any legislature. So does it mean that every custom or usage automatically becomes under Article 13? So the next word is important. Having in territory of India the force of law. It means that there should be a custom or usage which, even though not exactly a law made by legislature, but it is followed by the people of India as if it is a law. Now you might say that how will you determine it? So there is one mechanism to determine it, if there is a custom or usage which is enforced by the executive. Sabrimala, women not going, police is enforcing it. Even though not written anywhere it is not written. But the police is enforcing it. So it becomes a law. Right? It becomes a law. Why? Because it is having a force of law. What is the meaning of law? You have to follow it. That is the meaning of law. Right? So if someone is forcing you to follow it, so the source becomes irrelevant. That is valid for Article 13. In fact, I was reading yesterday, I told you before coming to class I read. So new thing came to my attention is that there is a very famous website that actually tracks all the major cases and day to day what happens. In that, this triple talaq case, in that there was a reply filed by Mr. Kapil Sibal in that, and the website is good because judgment always is not very good. The reply filed by all the lawyers, they are also very good. So one of the reply filed by Kapil Sibal, in that I was looking at the reply. So he actually pinpoints it that there was a lot of debate in Constitutional Assembly that should we add personal law, and the Constitutional Assembly decided against it. You should not add personal law. Right? So in that aspect, this word custom and uses should not include personal customs. Right? But the court have ignored that and said that no, it will include personal custom as well. Right? Now you might argue both ways that court is progressive. The court is progressive and they are not bound by the Constituent Assembly debate. They are merely persuasive in nature and the court is not persuaded. Right? They are merely persuasive in nature and the court is not persuaded. Same thing happened in the case of rule of law, Article 14 also. Right? I mean Article 21 procedure determined by, same thing happened. There was a lot of discussion and they specifically chose that no, I will not write the American doctrine into the constitution. But still the court chose to ignore it, saying that they are merely persuasive in nature. Understood that particular point? Okay, quite simple. So this word actually opens the whole scope of clause 1 and 2. Because rest everything everyone knows, if it violates fundamental right, you can go. But the real problem starts with the word custom or uses. Now with regard to personal law, you might say, okay, that is something the court did. But there are multiple trade law also, whereby the custom and uses becomes important. In fact, this word uses have been used in our Contract Act also multiple times. As per the applicable uses, you will do this. Yeah, unless contrary to the usage of the trade, you will do this. Right? So this word uses is not only important for the purpose of personal law, but it is important for the purpose of commercial law as well. Understood that particular point? Okay. What is that judgment name? The judgment name I will also tell you, very interesting actually. That website, I will ask you to visit that website actually. It's a very good actually thing, because it also provides for the argument given by multiple counsels. Yes, see, it is a free website. Argument given by Sibbal somewhere, see, on the Union of India. Sibbal, yes. This is what I was reading yesterday itself before class. In that he gives this. फिर से यहाँ जाना पड़ेगा. अच्छा आ गया, वाह. अच्छा, इसमें थोड़ी लेकिन दिक्कत थोड़ी है स्क्रॉल करने में, ये ज़्यादा अच्छा है, इसमें पता चलेगा. हाँ. In fact, he talks about here, considering the issue declined the above. Yes, State of Bombay. See, Justice Sagla. See, Justice Sagla in State of Bombay versus क्या है, Narasu Appamali. There is a distinction recognized by the legislature in one of the clear to look at the language of Section 12 of Government of India Act and this. And further he writes, this provision in the Constitution Act and having a model before them, the Act Constitutional Assembly, in word defining 13 of the law, have expressly and advisedly used only the expression custom or usage and have omitted personal laws. Right, so there was a specific debate whether we should have the word personal law or not. So the Constituent Assembly specifically chose that we should not write personal law. But our Supreme Court said that no. Usage and custom will include personal law. Because this debate that is going on all around, whether women entering into Sunny temples should be there or not, Jallikattu debate, same thing, whether it is one of the animal cruelty or one of the custom of the religion or not. Because once you open this floodgate, in India there is such a huge amount of custom, right, that you cannot stop. You literally cannot stop. Each and every custom is violating fundamental rights. And the best custom is marriage in caste. Go and challenge it once, then I will see what happens. Right? So either you allow the society to transform yourself, or do not, open the Pandora's box. Right? Because it will become such a huge thing that you will be not able to handle it. Because Indian society is full of the custom that is unconstitutional at the very face of it. एक चीज unconstitutional है. So हमारी बात, like where the after marriage where the women should live, what the custom dictates with the husband, unconstitutional. Article 14 violation. Right? Multiple things are there, but obviously we did not. Right? So you will mention this. I will also dictate you.